Hello and welcome to JResearch channel. Contract Act is one of the important subject which is covered under your UGC NET syllabus. So considering that, I'll briefly try to explore the concept of contingent contract, frustration of contract and force majeure clause. We are actually going to have a comparative study between these three concepts. Hence, let's begin this video. Let us just try to understand the concept of contingent contract. It's been defined under Section 31 of Indian Contract Act, and it's one of the prime feature is that these type of contracts are conditional contract. So the parties, while entering into a contract, fix some underlying condition and which must be of uncertain nature. Since that condition is a future event, hence it is uncertain, that might happen, that might not happen. And it's one of the essential element, because without the underlying condition, there won't be any contingent contract. Okay. Next point is that the condition or the event which is being pre-decided by the parties, it must be collateral to the main purpose of the contract. What does it mean? That the enforcement of contract only depends upon the condition precedent. So once that event or the condition has been occurred or fulfilled or accomplished, right, which is being decided by the parties, then only the contract will consider to be enforced, right? Third point is that contract already provides contingencies, which means that the condition or the event, which is collateral, it's been already decided by the parties, right? It's been already preconceived by the parties while entering into a contract, right? Hence, contingent contract is within the control of the parties. So finally, we can say, since the event has been determined by the parties, if it is a positive event, it will be governed by Section 32. If the event is, a negative event or non-happening of an event, it will be governed by Section 33. And if the happening, right, if the positive or negative event, if it is happening according to the parties, the contract will be considered to be valid. And if it is not happening according to the willingness of the party, then the contract will become void. Next concept is Section 56, which talks about agreement to do impossible act, or you may also call it as frustration of contract. So if you have referred the bare act language of Section 56, you might have came across the term impossibility, right? Section 56 is actually revolving around this term. It's very important. And under Section 56, you will find the categorization. Okay. Under Para 1, you will find initial impossibility, and under Para 2, you are going to find subsequent impossibility. Right. So these two impossibilities are described under Section 56. If I talk about Para 1, which is initial impossibility, it says that the agreement in itself, it was dependent on some impossible act. Then these kind of agreements will be considered to be void. There is this example which is being covered under your bare act under the illustration section, that the agreement for discovering the treasure through magic, then these kind of agreements will be void, right? Because this is completely impossible in itself. On the other hand, if I talk about subsequent impossibility, which is covered under Para 2, let us see what happens under this. So see, when a contract was entered into by the parties, it was valid, right? But some supervening event, what is supervening? Unforeseen. So when the supervening event has occurred, so this event has made impossible or impractical to perform the promise, and hence the contract will become void. Okay. So under the initial impossibility, there wasn't any contract at all, because the agreement was already dependent upon the impossible act. Whereas in case of subsequent impossibility, the contract was valid initially, but some event has actually made the impossible or impracticable to perform the contract. Right? So before you on the screen, I have actually categorized a set of instances which are covered under Section 56 under the green box, and the instances outside the scope of Section 56 are given under the red box. So you may pause the video and go through the instances. Now let us see that what are the other essential features of Section 56. So see, the events which has been occurring, the events which are actually frustrating the contract, they are not predetermined by the party, right? So you can just go through the instances of section 56 and you can see that they are not pre-decided by the parties. Like we have discussed under contingent contract, so therein the events were in the control of the parties. But under section 56, events are beyond the control of the parties. Next essential thing which you must remember is the remedy. What is the remedy which is being available for the contracts which is being frustrated? Right? So the remedy is given under section 65. So it's basically the principle of restitution. So this principle of restitution states that if a contract is void or frustrated, any person who has gained any benefit under that agreement or contract is obliged to return it. Right? So this is the important section which you must remember it. Our third topic is force majeure clause. It's a contractual provision. What does it mean? That the parties, while entering into a contract, they can add a force majeure clause, right? And it is also common in the practice as well. Now, what is the purpose of this clause? This clause basically covers those events which cannot be anticipated or controlled. It covers the events which are, natural calamities are there, or the artificial acts. Right, so it is broader than the vis major events. Then what will happen if this clause has been added? So when that particular event has occurred, then the contract between the parties, they might get suspended or cancelled, or the damages, if it has been there any, it might be waived. And the burden of proof lies with the party who wants to invoke the force majeure clause. Right, so this is the entire intent of force majeure clause. Since the clause is framed by the parties, so they should construct the language accordingly to include the set of similar events. Since there is no express provision with respect to force majeure clause, right, which is given under Indian Contract Act, it is basically juggled between section 32 and section 56. If we take out the precedents right before us, we can conclude that what the court has held, that the force majeure event which is relatable to the clause in a contract, then it will be governed by section 32 of the act. Whereas if the force majeure event occurs beyond the contract, then section 56 will apply. Right? Now, third point is that what if the force majeure clause is not present in the contract? Then any party could invoke the doctrine of frustration in this case, right? So this is what the concept of force majeure clause is. Now there is one important announcement that the enrollment for UGC NET 2023 Hive batch is open, to which the last date is 15th October. Under this, you are going to get extensive preparation with respect to paper 1 and paper 2 at the cost of just rupees 990 only. So do visit the website link given under the description box. Thank you for watching this video. If you like the content, then don't forget to like and share this video with your friends, and do subscribe to UGC channel to get the further updates.